Good morning.
Good morning, Your Honors. My name is Jonathan Ellis. I have the pleasure of representing Mr. Ellison, who is here today. Seated to my right is Elaine Walton Boyd Richards, representing the association. I'd like to reserve 5 minutes for rebuttal.
Okay. Let's talk a little bit about how we're going to do this. You've got a cross claim, right? In this case. So typically 20 minutes aside. We're just going to leave it at 20 minutes aside. You're going to address the main claim, the cross claim at your discretion. You're going to tell us whatever you want us to know within your 20-minute period.
I think they're mirror images, yes, Your Honor.
That's, I kind of thought it'd be cleaner and easier to do it that way. So, all right.
Thank you. So this case, Your Honor, arises out of Mr. Ellison desiring to put wood floors in his condominium that he owns.
Can I ask you a question? And I don't mean to cut to this.
No, that's fine. I appreciate it.
But if we reverse because the trial de novo was not granted below, is there anything else we need to do?
I don't think there's anything else you need to do unless you review the findings that the court made that number one does contradict it. So the rule does contradict.
Well, if you're sending it back for a trial de novo, and it's just kind of a do-over?
I think it is. I mean, I think it sends it back to the court to consider the full plea.
Because, I mean, the court applied the wrong standard. The court thought it was sitting in an appellate capacity over an arbitrator's award, right?
Correct.
I mean, to go back for a trial de novo, all bets are off. We're starting all over again, the way I see it.
Yes, I think we have to consider as a new trial would be the complaint, the answer, the actual affirmative defenses that were asserted in the answer, which actually are pleadings, and then the court needs to make a determination. Now, if you read the transcript, I think the court has already made certain determinations on the affirmative defenses.
For clarity's sake, on remand, you're not asking us here to affirm any rulings in your client's favor, like the second fine. So just a clean slate going back.
I think you can certainly affirm the second fine, to the extent Florida law is unequivocally clear. You only get a fine once, and I think it was a mistake. I really think the court has two choices. One is, look, it's the wrong standard. We need to remand it. You need to consider everything that's in the pleadings. I think the Florida Supreme Court has said, I think this court has said previously, or in the alternative, you could go by the rulings of which the trial court made.
As my colleagues have pointed out, the judge made those rulings after saying, I'm not doing this, but basically, I'm going to paraphrase. This isn't a trial de novo, this is a review proceeding. And so the court may be limited to the issues that were presented in the arbitration proceeding. And so if a particular issue wasn't really brought up, and then they try to bring it up, or somebody brings it up on de novo, that could be a problem. I'm not sure we have that here, but that could be a problem because that would, in theory, have done an end around the arbitration process.
So I think if you look at the arbitration statute in the Florida Condominium Act, it talks about the arbitrator dealing with a dispute. It doesn't talk.
Pleading requirements are pretty minimal. Everybody's on notice, essentially. The petitioner puts everybody on notice what it's claiming, the respondent, this is what it's asserting, and as long as those are set out, not necessarily the pleading requirements in court, and arbitrator addresses them, then those are fair game for a trial de novo, correct?
I think it's fair game, but I think the answer is there's a dispute over wooden floors, whether you can put them in and whether you're allowed to do it. The fact is that the arbitrator ruled that decision is given some deference, but I don't think anybody's hands are tied completely. You have to assert something.
The elephant in the room seems to be the association's argument that Mr. Ellison did not assert selective enforcement in the arbitration proceeding, or if he did, he's not allowed to because he's the petitioner. But as I read the petition for arbitration, it references essentially disparate treatment, which sounds an awful lot like selective enforcement, but without that.
The arbitrator puts this very clearly in the rehearing and in the decision, and that is selective enforcement is selective enforcement when you're using it as a shield against the claim that's made, and it becomes arbitrary and capricious when you're asserting it affirmatively. That is the flip side of the other. There's
But
an
it's
argument.
being, in this case, it is being asserted in the arbitration as a defense against enforcement action by the association.
Correct.
So at least as I view it, it seems to be used as a defense to the association's conduct.
It's exactly
Even,
being
even
used.
though Mr. Allison is the petitioner.
That's correct, because they find him. Because they find him. Normally, before you had fines, these things generally arose when the association moved to enforce. In this case, the association didn't move to enforce. In this case, the association just fined. Mr. Allison then winds up facing a fine, winds up bringing this issue to the division for arbitration, raises the issue of disparate treatment between, one unit owner and himself on a number of years. And now he raises the issue. How come you're treating me differently? You have one unit owner that just has to show a sound test of 50. I'm going to have material that shows 70. You went by her materials, why don't you go by my materials? And the arbitrator rules, the arbitrator specifically says, I'm ruling on this one issue. I'm going to address the rest of the issues. Opposing counsel, not sitting here at the table, but the association makes a decision. We're going to move for trial, but now judge, you can only decide one issue. And that's what the arbitrator decided to do in appellate capacity. But I think the answer is, Your Honor, I'm agreeing with you that I think that the issues were raised in the
You
arbitration.
feel the law to say you agree with me.
I'm sorry. And then I think if you look at the rule, if you're inclined to get it, if you're not, I certainly say to everybody a fair amount of time. But the answer is, if you start to look at the rule is clearly conflicted with what the declaration says. Declaration is clear. You got to have a standard. You got to have an average. Somebody is allowed to go to the association with information indicating this is the soundproofing. Associations created a rule when you look at it that is arbitrary and capricious on its face. What does the rule say? The rule says you got to do a test. You got to do a test before you remove a carpet. You have to do a test after you remove the carpet. If the sound is greater before you move after you move the carpet than before, you don't get it. But when you look at the rule, that's not what the rule says. And if you think about it, there is a different standard for absolutely everybody in the condominium association, depending what type of carpet, what type of soundproofing, what did you have before, and what, and we think we went through issues in the actual brief indicating what happens when you have averages where somebody clearly put in a certain type of flooring and their neighbor couldn't, based on the carpeting or the sound barrier that they had in advance. That by definition becomes arbitrary and capricious. And if you think about it, you can manipulate it. Somebody wants to turn on Mr. Allison wants to manipulate it. He can have totally great soundproofing carpet and a barrier. Turn around without an association permission, put in a new carpet, a very thin sound transmission carpet. And this is where this rule just becomes arbitrary and capricious. And that's the issue that we're dealing with. By definition, this rule contradicts specifically what the declaration says. And you can't create a rule that contradicts the declaration. It just becomes improper under existing Florida law. That's what this does. It gives a different standard for absolutely everybody. 3, you wind up having the board of directors that actually adopted when the debt was clear.
That issue was not resolved by either the arbitrator or the trial court.
That was not, and I think what happened on that is that I think the trial court actually says in the transcript when you read it that they found the rule wasn't adopted. She said the rule wasn't adopted, but then goes ahead and does a ruling notwithstanding. So there's language from the trial judge that says it was not adopted properly in the transcript. And I think when you start to look at the ruling in the last few pages of the transcript that the motion for summary judgment hearing, it's often difficult to follow on exactly what was ruled. You had a number of rulings in favor of the association, and then you have a written order where you're trying to figure out how to do this. You have competing orders going to the court, and the court just picks one as opposed to the other, but the one that's picked actually contradicts a fair amount of the language that's actually in the transport at the front of the ruling. When going back to rehearing, well, this is not good. I'm not gonna be able to sign it here, but like to say, I'm sorry, go ahead.
Any proceeding in the circuit court, did any offer any new evidence other than what was presented to the arbitrator?
There were depositions and affidavits that were filed that may have done it in a more formal aspect, but I think if you're asking at the time of some judgment, I don't think there was any critical evidence that was provided to
The
the.
substance was basically what was before the arbitrator.
It was basically what was before the arbitrator, except for the fact the arbitrator made a decision, I'm finding on one issue, I'm not going to decide on the other one, then you go to court. And the answer is, well, I'm not going to find selectively enforceable because there's no authority to do this, but because I have to flip the arbitrator's order, I believe what ultimately happens is I'm done, I can't consider anything else, and that's the mistake that we are claiming is the first issue. I think the main issue dealing with the standard review is supposed to be a new trial. I think when we did step in court, when we helpful that, you know, trial doesn't necessarily mean a quote trial. These things can still be determined on some
They
judgment.
call it proceedings de novo.
No, I'm just, yeah, I mean, I think I don't want to have a false sense of that you absolutely unequivocally have to have a trial. You can do this as you would in any other case, and these same issues that will below. Unless there's any other questions, I'll see my time for Thank you.
You'll have 5 minutes from now.
Thank you.
Good morning, Elaine Walter from Boyd Richards Parker, Colorado.
Maybe we should change it.
I'm representing the grant at Old Carrollwood.
Good morning.
Good morning.
How do we not send this back for a trial de novo?
Here's how. The con case cited to by opposing counsel in their initial brief, and let me get right to it, says that if something is not ruled in your favor in arbitration, you don't have to bring up something that's ruled in your favor in arbitration, but you do have to bring up the rulings that were not in your favor in a counterclaim. And that is Con versus Villas. I can get the citation if you need it. Mr. Allison did not prevail on the issue that the rule was inconsistent with the declaration. He did not prevail.
So arbitrary and capricious in the arbitrator's findings mean what?
So the arbitrary and capricious was as to selective enforcement and not arbitrary and capricious rule in and of itself.
Which is what Judge Thomas says you can't use selective enforcement. When you're alleging selective enforcement in your complaint in paragraphs 49 through 61, it's at play here. I mean, tell me why this doesn't need to go back. You guys are using it in different ways.
Right. And a
This
little
was
bit
not
further,
right for summary judgment.
a little bit further on my argument.
Let me interject something together, because I said something to opposing counsel that I would like you to address, which is if an issue was not presented in arbitration, I'm not convinced that a trial de novo lets new issues be interjected, because that would avoid the mandatory requirement for an arbitration, non-binding arbitration before. But the flip side of that is anything that was raised as an issue in the arbitration seems to me to be fair game in the trial de novo if pleaded. So your client pleaded certain things, the other side pleaded certain things, all of which nobody argues was before the arbitrator. And I understand the characterization, well, selective enforcement wasn't used properly, it wasn't really pleaded. Everybody seemed to understand selective enforcement was an issue because your side filed a brief arguing why it shouldn't be considered or shouldn't be ruled in favor of the other side. So tell me what I'm missing as far as the trial de novo aspect. Isn't everything that was in front of the arbitrator, ruled on or not, as long as it was down there, then it's fair game in the trial de novo?
It is, Your Honor, and I agree with you, both of you, that it is fair game for a trial de novo. However, our theory, and maybe it's not a theory you will agree with, is that the issues that were before the arbitrator that you did not win on, i.e. Mr. Allison did not win on the rule conflicted with the declaration. He didn't win on the rule wasn't promulgated in the correct way. Those should have been raised as part of the counterclaim, not as affirmative defenses.
If the association is trying to enforce a rule and they are asserting as affirmative defenses anything that relates to that issue, what authority is there that that's not appropriate?
I couldn't find anything that wasn't.
But I'm not sure there's any authority supporting that argument.
I understand that, Judge Silverman. I couldn't find anything that said it was or wasn't either way. I wish I could have, I would have cited it in my brief.
But in terms of what a trial de novo is, you would agree that the defendant in a trial de novo gets to raise affirmative defenses.
Absolutely.
Okay.
Yeah, absolutely. But let me keep focusing on why you don't need to send it back for a trial de novo again. The trial court did rule on the bulk of the issues, whether at least included them in findings of fact and conclusions of law.
But did so applying the wrong standard from the very inception of the order based on the request of your client.
And you can review that standard application of the wrong standard de novo here. So it's our position that you were able to go ahead, look at these competing motions for summary judgment. The rulings, the statements that are within the trial court's order, and say yes or no.
The trial court applied was essentially a review standard, not a trial de novo standard. Even though she made findings of fact based on what was before her, she did so through the lens of review as opposed to trial de novo, correct?
I do believe so, yes. Yes, Your Honor. But assuming you agree with me that you don't have to return this for a trial de novo, I'm going to argue the rest of my arguments. And I will try to make them brief.
If we go along the way you're suggesting, our role would be to review the record to see if there's any evidence to support the findings that she made, correct?
Correct. Yeah. So with that being said, I'll move on to whether the rule is consistent or inconsistent with the declaration. It's our position that the declaration says the architectural review committee may consider whether the change will cause noise to any unit below which exceeds the average noise level in units, but it doesn't have to. It doesn't have to or something there. It's a may, not a shall. It also says that the owner applying for such approval shall provide to the developer or the ARC information regarding noise level factors, as well as any information requested by the ARC, I'm paraphrasing, as well as that noise level requirements shall be considered to be met if the owner provides a sound transmission test that the proposed flooring will create less noise than the standard level set by the reasonable regulations of the developer, or the ARC. The standard sound level is the set for that the ARC decided the rule is a sound test before and a sound test after to make sure that there isn't a change in level of sound that impedes the enjoyment, reasonable comfort of the unit owner below the second floor unit. Do you have any questions on that?
But the article of declaration 23U does seem to set out the standard that's supposed to apply, which is the average noise level in units below units. So doesn't the rule basically say, well, let's not worry about that. Here's another way you can do it, or here's the way you can do it. Or doesn't that depart from an established average that is supposed to be made available to unit owners?
I don't think so, Your Honor.
But, and I know, sorry to interrupt, but it also brings up the question of whether it's properly adopted or not.
And I'll get to the properly adopted in a moment. As far as whether they have to consider an average, it's a may, not a shall. They don't have to consider an average. That's one of the things that they can consider.
Well, may consider whether the change will cause noise which will exceed the average noise level. The will exceed seems to be a mandatory bit of language.
Okay, all right, I understand, Your Honor. But then
Well, do you disagree or do you agree?
I disagree. I disagree.
Always my favorite answer.
I disagree. Because an average noise level can be done in different ways. And you can test all of the units, you can test 5 of the units, you can test 2 of the units, I guess. That's what somebody chooses to have as an average. But the onus for providing that average, the way I'm reading this, and maybe I'm incorrect about this, is that the owner applying for approval has to give the information regarding these factors. So
is the owner supposed to go into every apartment in a particular building or multiple buildings to come up with that average?
it would appear that that is a possibility under this rule.
Right. I'm having some trouble buying that. And what about the second part of the language in the declaration, which talks about providing a transmission test that establishes what the noise level is? Isn't that what Mr. Allison tried to do when he said, here's information from the manufacturer?
He didn't provide a sound transmission test. He provided documents from the manufacturer. He didn't ever engage in a sound transmission test, not pre, not post, not ever, even when there was an accommodation that from the association saying, go into one of your other units that you have, do a pre and post test there.
It doesn't restrict the owner to doing an on-site sound transmission test. It just says sound transmission test that they proposed for will create a noise level less than a standard level set by reasonable regulation. So again, we're back to a standard that's supposed to be set. Why would a manufacturer's test as far as sound transmission levels installed in a certain way, why would that not be enough? Or do we need expert testimony to say that is enough and here's why?
Right. The association tried that with another homeowner, a unit owner. They let them, this was the Cohen case. It's the only time we ever deviated from this rule in the history of the since turnover to the association. And there, we permitted that homeowner to settle anything that was happening litigation wise. Well, that's where we get there, but it was a.
And your client said, well, we're really sorry we did that because now it's creating problems.
Not necessarily, Your Honor. I have an argument with that too. I just haven't gotten there yet. So they let them do a 50 IIC. He's the one that understands these sound levels better than I do, but a 50 IIC level. And immediately there were complaints after that flooring was installed by both the owner and the tenant. Unfortunately,
But we don't know if it met any standard as far as what sound transmission was acceptable, correct?
that is true.
Okay.
That is true. I'm going to keep going for the other issues.
I would still like to circle back to less than a standard level set by reasonable regulation of the developer in our city. And I think we agree that was not done.
I think the association thought they were doing what they should be doing to
Again,
what they
is there
needed to do.
evidence like that a standard level set by reasonable regulation?
If you're looking for a number standard, Your Honor, no, that was never done. What they did was try to do like I said, the pre and post test to make sure that the person who was below the unit that was having hard surface flooring installed didn't have a higher noise than they did before. As far as the rule being reasonable, it's a matter of law. That argument is that under Hidden Harbor and Beechwood Villas, it has to be, a rule has to be reasonable to promote the health, happiness, and peace of mind of unit owners. That is what the association is trying to do in enacting this rule that they did. And as far as whether the rule was properly enacted, the argument here is that the ARC should have been the one to promulgate the rule. 718.122 and anything else in chapter 718 does not give that right to an architectural review committee. That right is given to the association. So in this case, we think it was done properly, enacted properly. The ARC set the rule, they gave it to the board of the association board voted on it, and then it became a rule. So it wasn't as if it did not come from the ARC, it was their rule, and then it was just adopted and put into action. As far as impermissible selective enforcement and why there is none here, I'm looking at White Egret versus Franklin, the Florida Supreme Court. Its selective enforcement is not available when he's the one seeking relief. I understand Your Honor's argument, Judge Silberman, that we find him, so maybe he is in the posture of not the petitioner, but he was the petitioner in the trial or in the.
But I don't think anybody cited a case that I found, which is, it deals with an RV. It's called Fountain View RV Lot Owners Association from the DPPR, and that was not cited in your client's memo to the arbitrator, but that case does seem to be pretty squarely on all fours with what happened here, which is someone who is being fined or challenged as far as what they're doing. They filed a petition and they raised selective enforcement, and the DPR ruled on it as selective enforcement. So there was at least one case that it doesn't seem like anybody found that does that approach.
And I did not find that one, Your Honor, or at least my trial counsel didn't find that when he was working in the arbitration. There are a number of cases, the Dayton and the Dado that were assigned, that we cited in our, both in the petition response level and in the trial court. And there, basically, those cases say you can't use selective enforcement as a sword, only as a shield, unless there are other equities. And those equities in Dado were, the association had a long-term practice of permitting similar vehicles to be parked that the petitioner was asking to park. And
well, if you look at equities, wouldn't we consider the fact that your client imposed 2 fines and wants to collect them? Your client has directed that the flooring be torn up and wants that to happen. So doesn't that seem to put the other side in the posture of defending against the association's actions? I think the answer is yes.
my answer is maybe. I'm looking at the selective enforcement specifically, and the selective enforcement equities are what has happened in the past.
It's not next argument, but I think it's fairly persuasive, which is if the association starts imposing and accumulating fines and interest and other fees, we can't do anything about that without first filing a petition. And your response might be, well, until we take some legal action to enforce, so be it. But it does seem to me that they are in a defensive posture in terms of what they are asking the department to consider, the arbitrator to consider.
And as far as the equities, Your Honor, I think we also need to consider the fact that Mr. Allison filed an application and said he was going to do a number of things, never mentioned surface flooring. Asked about hard surface flooring, was told, you cannot do this. Here are regulations.
The equities may not be one-sided, but there are equities to be considered.
Correct. As far as the double fine, if Mr. Allison should not have been double fined, I think I can get my client to concede that that shouldn't have happened.
I'm sure Mr. Allison would be appreciative of that, but we're not making a ruling at the moment on whether they have to or not.
Do you have any other questions? I think I've gotten through everything other than a chattel shipping letter, whether that should have been sent. Because it was a single incident with the Cohen case. It was a result of compromise. We say that it didn't need to be. It happened before Mr. Allison took title to Unit 165. He was also on notice. I discussed that he had requested numerous times, what do I have to do hard surface flooring? And he knew what he had to do, and he didn't do it. And the association was not the one seeking to require action under the declaration of war. So with that being said, my request for relief is that you remand for entry of a summary judgment in the association's favor in all respects on the issue raised in the competing motion for summary judgment. Thank you, Your Honor.
Thank you.
You have 5 minutes, sir.
Let me try to be quick. Thank you. I want to go back to what the court did rule in the summary judgment hearing, even though the order was not necessarily fully reflected. Court at the end of the summary judgment hearing says, well, here's what the court determined, that the rule enacted by the association conflicts with the rule of the developer or the ARC as set forth in the declaration. Court further finds the association does not have the authority to enact a rule that is not in accordance with what is established in the declaration, and that requires approval powers be vested in the developer and or the ARC. Court further finds that the association does not have the authority to fine a resident twice, and it goes on, and you're finding a ruling, and then somehow when you look at the written order that comes out, that's not what it does. There was a question that came up, what is the dispute? I think if you look at Florida Statute 718-1255, dispute is defined or is used in this term, means any disagreement between two or more parties involved, and then it goes through. This is one of them, dealing with the use of a unit, and it's the dispute that has to be raised, not necessarily absolutely every affirmative defense, not necessarily every issue, but I think you put the dispute up there. It's designed to allow unit owners or citizens to go ahead without having to go through the arguments process of the court hearing to determine, try to get a ruling from the court. You have the arbitrator basically says, footnote 1, page 1 of the order. There are many issues and arguments that have been raised by the pleading documents in response to the memorandum of law. However, the arbitrator concludes that the rulings of those issues are unnecessary because it's determined the stated issue is the spot of this proceeding. So it went to one issue, not all. You take opposing counsel's argument. I think opposing counsel's argument is simple. Well, because he didn't get to all of them, now you have to file a counterclaim on all of those issues before the court, because the arbitrator went to one issue that was dispositive instead of all of the issues that were raised. And I think that's just wrong. And I think if you wind up looking at TA Enterprises, Polar 835, 7 1235, the court in the fourth DCA states that we read the appellate's argument because there's a trial de novo. The rules of civil procedure necessarily govern all matters, and that the trial court therefore ordered considering matters outside of its plan. The civil action contemplated by Chapter 681, this is dealing with arbitrations of the Lemon Law. The Supreme Court and other courts have indicated that similar sort of review is a proceeding to review the correctness of the arbitration decision in trial de novo. Is not required in party and arbitration plea cause of action entitled to review in the same way the plaintiff would ordinary in civil action must plead a cause of action entitling it to relief. Instead, the Lemon Law merely requires the losing party losing the arbitration to file a petition stating that the action requested grounds for relief on the review. And I think you have the same thing to the extent you're the defending party. You now end up having and you're starting affirmative defenses instead of a counterclaim situation. And keep in mind, and this occurred to me as I was preparing for this argument, parties flipped. Now, the association is the plaintiff in the trial court, and Mr. Allison is the defendant, and now Selective comes into play because he is defending against the action of the association. Thank you.
Thank you both. Interesting case. That's an interesting issue. And thank you both for your briefs and your arguments there. Well done. Next case is Afghani versus Republic.